Good afternoon. I am Scott Carpenter from the Carpenter Law Firm. Today we are talking about you've been called to testify in court. Now, what are we going to do? And it's October 15th, 2024. The information today is accurate on October 15th, 2024. And it's good for today. And I can't verify that it's going to be good in a year or 2 or 3 years from now. So every once in a while, a director of an Arizona community association or a professional community manager is called to testify in a legal proceeding, whether it's before the Department of Real Estate or in court, whether it's in Superior Court in one of our 15 counties or in a justice court or in a deposition. And these things happen somewhat routinely. Now, for a lawyer and a litigator like I am, these things are routine for us. But for the average professional community manager, it might happen once a year. It might happen once every 2 or 3 or 5 years. It may happen once in a career. But if it does, this is what to expect and how it might go and how we as lawyers approach the process of a professional community manager or a director testifying in one of these situations where the person, director or professional community manager, is put under oath and must testify truthfully. So you've been called to testify. Now, what are we going to do? Well, here are a number of scenarios where this might happen. And I had a client last week where the first scenario actually came up, a criminal scenario where the association was supposedly a witness to a crime. The scenario was essentially that the association was a victim of a crime. Someone had stolen electricity from the association, and some homeowners were very upset by this. Imagine the owner of an electric vehicle stole electricity from the association's clubhouse, strung an electrical cord to the electric vehicle, and the owner of the electric vehicle was a complete stranger to the association. Let's call the association Del Boca Vista. And a stranger pulled their car in and charged it using an extension cord from the clubhouse. That's not exactly how it happened, but let's just imagine that. Well, according to the prosecutor, the association is the victim of this criminal trespass and the theft of electricity. And in order to prosecute the thief, the owner of the vehicle, the prosecutor's prosecutorial standards say that the victim, the association, has to testify. The victim has to care about the theft. And the homeowners who witnessed this, the offended homeowners, the irritated homeowners, are not the association. And the professional community manager said, I'm just not that excited about getting involved in this. And the professional community manager's employer, the management company, essentially said, not that excited about getting involved in this as a company. Maybe you can appreciate that. So this is a scenario where testifying becomes an issue. Now, you can also appreciate that the professional community manager said to me, I didn't see anything. I was not there. I did not see the theft. I did not see this person plug the extension cord, and I'm saying that inaccurately, of course, but I'm sort of making a point. I did not see this person plug in and steal the electricity. I can't testify to that. I didn't see it happen. So the prosecutor said, I'm going to have to dismiss all of this. It was a paper ticket. It wasn't an arrest with any kind of drama, handcuffs, or anything like that. I'm going to have to dismiss all of this if the victim, the HOA, cannot step up and be a real victim, behave like a victim and act like you care. Um, the homeowners who were offended because they saw this happen are just going to have to deal with their offense, essentially. So that's one of the scenarios where this can happen, and this criminal situation is somewhat rare. We don't want associations committing crimes where the association is accused of criminal conduct, and we're in a situation where the association has to take the witness stand to avoid jail time. That's kind of a convoluted suggestion, but it's not really what I'm talking about. The second scenario is civil depositions where before trial, where the association is either the defendant, the side being sued, or the plaintiff. And there is a civil deposition where either side is trying to get information, testimony under oath before trial. And this could happen at any time before trial. Sometimes this happens at some point in a civil trial scenario. I needed a little help there. Okay, a civil deposition before trial, usually called by the opposition, but sometimes it can be a friendly deposition where we need information under oath before trial, and we call a friendly deposition of our own witnesses, but it's actually somewhat rare. So, testimony under oath with a court reporter, sometimes video recorded, prepared for trial. It really is courtroom testimony, but it's done before trial. We get a transcript, and like I said, sometimes it's videotaped. There's another type of deposition called a 30B6 deposition. This refers to the paragraph of the statute, rule of civil procedure, that says you can take a deposition of a person who is designated to be the spokesperson for a corporate entity. These can be difficult, actually. So if the association has sued someone, let's say we're in a dispute with a homeowner, it's a collections case, it's an enforcement case, and the attorney for the homeowner asks for a 30B6 deposition. These can actually be somewhat challenging because the homeowner's attorney wants to depose someone. That's take the deposition of someone under oath who is going to be the spokesperson for the corporate entity. In this case, we'll call it the HOA, and ask detailed questions of the person who is legally obligated to be for that 2, 3, or 4 hour deposition. It can be grueling to be the official spokesperson for the corporate entity. And it can be difficult. It's somewhat difficult to prepare someone to be the spokesperson for the corporate entity. Sometimes the questions can go back years. I've had situations where I've tried to prepare someone to be the 30B6 spokesperson for the corporate entity. We get the questions in advance, or the range of questions in advance, and then the questions they become very difficult, actually. They can go back in time. They can drill down into details. And one of the challenges we have, of course, in the HOA world is that the manager, if the manager is the designated 30B6 spokesperson, the manager does not know the motivation or the reasons why the board makes the decisions that the board makes. Additionally, a board president does not know the motivations or the reasons why the management company makes the decisions the management company makes. So if a board president is going to be the 30B6 spokesperson and speak to ledger entries on the accounting side, it's difficult because the board president did not make the ledger entries. The management company did. The treasurer didn't do it either. The management company did the accounting. And that's not a criticism. It's an observation that when you have a 30B6 and the spokesperson is the management company personnel person, they can't speak to the board side. When the 30B6 person is from the board, they can't speak to the management company side or the management company functions. You can appreciate the challenge. And so the good news is they don't happen in every case. But if you're ever designated as a 30B6 spokesperson for the corporate entity, just know it's going to be a challenging deposition. By rule in Arizona, a deposition cannot last more than 4 hours. I've actually been deposed for 4 hours. I was involved in a case a number of years ago. I say a number of years ago, it was actually longer than that. It was probably in the early 2000s. That's what happens when you're at this for as long as I have been. You think, oh, that was just a few years ago. No, I remember it well, but it was actually probably 2002 or something like that. But everybody was so busy at the time that we did it on a Saturday morning. And it did last 4 hours at somebody's law office downtown Phoenix. And it was difficult. It's difficult to sit in a conference room for 4 hours and have an attorney. It feels like they're in your face, grilling you, challenging everything you're saying for 4 hours. And it's made me a better lawyer to be on the receiving end of a difficult deposition for 4 hours. I know what it feels like. I know what it feels like to be prepared by a lawyer. It made me better at preparing witnesses, made me better understand what it's like to be on the receiving end of a 4-hour deposition, both physically and mentally. And also, the attorney at one point tried to make me mad. And internally, it sort of worked. I never admitted it, didn't show any emotion. And when I get to my 10 tips for how to handle testifying, you'll see that we'll talk about that again. So the civil depositions come up a good bit more than testifying at trial, because one of the goals of a deposition is to obtain enough information to improve the settlement posture of a case so that we can resolve cases before trial. Trial's expensive. The other part of a civil deposition is preparation. There's an old rule, I say an old rule, it's probably still the rule, that an attorney should spend 2 hours of preparation for every hour in the deposition. That's what makes depositions and discovery so expensive. If I'm taking your deposition and I anticipate it's going to be a 4-hour deposition, then I should spend 8 hours preparing. That's a 12-hour deposition. That's 12 hours of attorney's fees to take your deposition. When I started practicing law in 1994, my hourly rate was $85 an hour. For those of you who know my current hourly rate, you might say, well, geez, can we go back to that? That would be amazing. And you think about how long things take and the algebra of an hourly rate times the hours that projects take these days. 8 hours plus the 4 in the deposition, 12 hours for a 4-hour deposition. Things have really changed, but it's expensive to do discovery. It's expensive to do these depositions. Defending a deposition when it's your client being deposed Shouldn't take 8 hours of prep to defend a 4-hour deposition, of course. A little bit of prep to, hey, this is what it's going to be like. Um, Tell the truth, things like that. But when you're taking a deposition, that's where all the preparation is. So these are the scenarios where managers and directors and other HOA leaders can be caught in the vortex of testifying. Criminal, civil depositions, and then every once in a while we go to trial, and this is where you're in court, take the witness stand, and deal with the judge or the jury, judge and jury, perhaps, an enforcement trial, or perhaps more often than an enforcement trial is an assessment collections trial. I've done many of these in my career, and the assessment collections trial perhaps happens more often than the enforcement trial. And the assessment collections trial for more people in a management company is, here's the ledger, here are the payments, this is a business record, and this is when we received payments. These are the payments that are missed. Here's the total. And is the homeowner in the courtroom today? Yes, it's this person over there. No, we don't actually do that. Not that much drama. That's just for TV and movies. Can you point the debtor out in the courtroom today? No, I'm kidding. We don't do that. So these are the scenarios where you could be caught in the vortex of testifying. But it's not a vortex. We actually do pretty simple things. Who are we dealing with? What happened? Where? When? And why? When we testify, just so we kind of get the full context of what's happening in court, court only cares about two things: facts and the law. What are the facts of what happened, and does the law care about it? It's really that simple. What happened, and does the law care? And we divide these two things up between two different groups of people who have to decide these two different sides of the coin. Attorneys argue about the law in pleadings and motions to the judge. Judges decide legal issues, and juries decide the facts. And in some types of cases, the judges decide the facts. Now, in collection cases, in justice court, small dollars, judges decide the facts and the law. We go to justice court to get judgments against homeowners, and in nearly every case, the judge decides the facts and the law. But if we were doing a lien foreclosure in Superior Court, and a homeowner wanted to impanel a jury on the fact question of, did I make all my payments? Do I actually owe that money? A homeowner could do that. A homeowner could request a jury trial on whether the ledger is accurate, about whether the payments were made. But homeowners don't do that. And we might ask the hypothetical question: why is it that we don't have jury trials in lien foreclosure cases? The reason, I believe, is because the ledgers are accurate. Homeowners are missing their payments. We don't have grave injustices where management companies are receiving checks and shredding them so that we can create unjust lien foreclosures and steal people's homes. That's not what's happening. And then we're doing lien foreclosures. Again, I'm giving you the unjust version so that we can do lien foreclosures and have homes sold at auction to steal homes from people. Obviously, that's not what's happening. If that were happening, homeowners would ask for jury trials to prove that they made their payments and the ledgers are unjust and wrong. But we don't have jury trials. so that homeowners can prove that they actually made the payments. We also tend to not have jury trials in enforcement cases, although every once in a while we do, about whether the purple gazebo in the backyard was actually approved, and there was just a mess in the paperwork between the homeowner and the management company. So every once in a while, we have jury trials there. But in many cases, homeowners and their lawyers figure, let's just opt to have the judge decide the facts and the law. We generally believe, and I'm speaking for lawyers on both sides of these cases, that the judge can fairly and justly decide both the facts and the law in both enforcement and collection cases. And so that's one of the reasons why we tend to not have very many jury trials in either collection or enforcement cases. But if a homeowner wanted to push the point and impanel juries in their cases, we probably could. But also, if you think about it, there's so much I hate HOAs sentiment out there in the state. HOAs and those of us lawyers that represent them, it would be weird for us to want a jury of randomly selected Pima County, Maricopa County, Coconino County citizens to be impaneled and to hope that that randomly selected group of 12 jurors would be friendly to the HOA's argument that the homeowner put in the wrong windows or put in the wrong colored door or whatever the argument is. We generally believe that juries are not good for the association's position, whatever it might be. So we don't generally want jury trials, although homeowners in general and their lawyers think juries will be more favorable to the owner's position. So that's one of the reasons why it ends up that way. We're more generally, I'm speaking for the association attorneys out there, including me, we generally believe we want judges making decisions because they understand the law and that the law is generally more favorable to the association's position. All right, so this is what we're doing on the fact side, because testimony is usually, it's almost always about the facts of what happened. And the fact finder, that's what we learned in law school. The fact finder is going to decide the facts, whether it's the jury or the judge as fact finder, and the judge is going to decide the law. And that's going to generate the result. The jury or the judge as fact finder, we don't say the judge as jury. The jury is the fact finder or the judge acting as fact finder. It's important nuance there. And the judge will decide the law. And you're going to testify when you do to the facts. Here's the ledger. The ledger goes back to 2017. It shows consistent payments for 3 years, and then the homeowner stopped. And this is the ledger. It shows that they currently have a balance of $4,000, and they currently owe $4,000 today. They stopped paying, and I'm going to make a joke right now, and that's them in the courtroom right there. I'm joking, of course, that we don't do that, but that's your factual testimony in a collection case. In an enforcement case, I do my standard inspections once a week. I drove by the house on this date. I saw that they had constructed a purple gazebo in the front yard. There's no record of any application under the CC&Rs. They have to get permission to make any changes. And I sent a letter dated such and such. You modified your property without permission. It said that. They didn't apply for a change after the fact. We sent it to the Carpenter law firm. They sent a demand letter. They didn't submit for approval. And after a certain period of time, we filed this lawsuit. And that was the extent of my involvement. And it's still there. And Your Honor, that's all I know. And that brings us up to the end of my involvement. That would be the extent of a manager's testimony, perhaps. And then I would point to the TV screen. Is this an accurate picture of the purple gazebo? And you would say, yes, because we've prepared. That's how it might go. All right, so under the law, what are we doing in court? Well, there's a rule of evidence that says before you testify, you have to affirm to testify truthfully. Here's what it says. And this is a rule of evidence that really requires the judge. And by the way, we use the word judge and court as synonyms. So the court has to abide by this rule of evidence. It says before testifying, a witness must give an oath or affirmation to testify truthfully. It must be in a form designed to impress that duty on the witness's conscience. So the judge must run a courtroom in compliance with this rule. Some people think that the oath has to say, I hereby swear to tell the truth, the whole truth, and nothing but the truth, so help me God. But that's not actually what the rule says. It doesn't say that the witness has to say, I swear to tell the truth, the whole truth, and nothing but the truth, so help me God. And in fact, that last part about so help me God is not in there at all. That's kind of a made up part of it. The clerk of the judge's courtroom might say, repeat after me, and that might be his or her version. And there have been a number of cases that have gone to court about whether a witness has to say that part. They may be offended by that. And the Supreme Court in Arizona writes the rules of evidence. And as you can see, that's not in there at all. And in fact, one does not have to mention a deity at all. And in fact, it's been stripped away. And so simply affirm, I'm going to tell the truth in a form that's designed to impress that duty on the witness's conscience. And it doesn't have to be administered by the clerk. You don't have to put your hand on a holy book of any type. And the judge has to simply do his or her job to make sure the witness understands the obligation to testify truthfully. So that's what you need to be prepared for. And the court reporter might say, I'm going to put you under oath to tell the truth. And there's nobody there to resolve any argument over what he or she says to say in a deposition. So if you're offended by what the clerk says to say, just remember from this webinar, don't be offended. Be offended if you want to, but it's going to be easier to just gut through it and tell the truth in the deposition. And I'm not telling you to suppress your conscience, but this is what the rule says, and there's nobody there to resolve it. And what you might end up doing is creating a fight between the lawyers, because when in a deposition, there's the court reporter, there's a lawyer for you, there's a lawyer for the other side. And if you pick a fight over the very first thing that happens, which is you being sworn in to tell the truth, then the lawyers are going to argue with each other. And the one thing we know is that a few years ago, judges got so sick of lawyers in depositions calling the judge on the phone, and the judge might have been in the middle of trial. The judges have busy days. And lawyers who couldn't get along started calling judges to resolve the disputes that were occurring in lawyers' conference rooms in the middle of a deposition. And as you can imagine, Judges hated it. I mean, imagine that. You're a judge, you're in the middle of your day, and your judicial assistant, your judicial paralegal, for lack of a better term, gets a phone call from two feuding attorneys in some lawyer's conference room somewhere saying, Judge, we've got a dispute. We want you to resolve it right now. We're in so and so lawyer's conference room, and a witness will not take the oath. What do we do, Judge? I mean, you're not even in the courtroom. There's nothing for the judge to do exactly. And so what the judges have done is basically said, don't do that. Don't call the judge in the middle of a deposition. So I didn't mean to meander on this topic, but in a deposition, just be aware of how this oath is set up and that it doesn't actually require you to mention a deity. All right, so what is perjury? Perjury, as you know, is lying under oath, and here's how the criminal statute reads. A person commits perjury by making a false sworn statement in regard to a material issue, believing it to be false. So you have to know it's false when you say it, or it's either of these two: a false unsworn declaration, certificate, verification, or statement in regard to a material issue that the person subscribes as true under penalty of perjury, believing it to be false. It's a class 4 felony. So we've got to tell the truth. And if we don't, it's a felony. Now, there are not a lot of, and this is not good, I don't mean this to sound like it's permission. There are not a lot of prosecutions for perjury. And the reason is right there in number 1. You have to believe it's false when you say it, which is, kind of you have to know it's false, I guess is my point. You can't accidentally commit perjury by saying something that's not true without knowing that it's not true. All right, here are my 10 tips, and this is really where the rubber meets the road. When you've been called to testify, these are the 10 things that you have to keep in mind. And the first one is always tell the truth, obviously. You're under oath, you have to tell the truth. Now, here's where we get a little tripped up is, well, Scott, if I tell the truth, someone's going to get in trouble. I know things. And if I tell the truth, then it's going to hurt my company. If I tell the truth, it's going to hurt the board members. I know things that will make my company look bad. Well, nobody wants anybody to commit perjury and commit a class 4 felony. So I've seen a lot of situations in my career where people say, well, you don't know what I know. I'm like, well, let's talk about it. And I've heard a lot of things, and that nothing phases me anymore. Let's tell the truth and then figure out what to do with it. So that's number 1. And numbers 2 through 10 are important, but number 1 is important by a mile. Always tell the truth. We can pretty much work out anything else that happens, but we've got to always tell the truth. My wife and I raised 3 daughters, and I said to them many times, never lie, but especially never lie to your doctor and never lie to your lawyer. Please, 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 oh daughters of mine, don't lie in life, but don't lie to your doctor and don't lie to your lawyer. Please, please, please. One of my most famous parenting lines to them. And they'd say that today. Yeah, Dad, don't say that again. I've heard it too many times. You can have that one, all of you that are watching. All right, number 2, critically important. You know how sometimes, you have friends, you're in a conversation and they can't wait for you to finish your sentence and then they just jump in. Don't do that in this scenario. Do not jump in. Wait until the entire question is asked. Don't jump in early. Wait until the person asking the question puts that period at the end of the sentence. Please, 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 don't jump in early. It's not a game show where there's credit for answering soon or hitting the buzzer early. Don't hit the buzzer early. Number 3, answer only the question that was asked. My wife and I were watching Survivor last night. We're a little behind. We were watching one of the episodes from this year. And Jeff Probst was asking at the tribal council if anybody had anything else to say. And one of the players said, I have something else to say. I looked at my wife and I said, please no. It can't be. There's nothing else to say. And that's what this is sometimes. And then she said it and I thought, oh, that did not. It didn't help anything. And if you watch Survivor or not, it doesn't matter. She had something else to say and it contributed nothing to her position, didn't help anybody else. That's what this is. If the conversation's over, don't add anything else. Don't answer, don't say something that's not responsive to the question that was asked. Number 4, it's okay to take your time, think before answering. There's no electrical buzzer under your seat that the attorney's going to use to zap you if you take too much time. There's no penalty. The judge is not going to be irritated, and irritation doesn't matter. Even if the judge is irritated, there's no penalty. There's no penalty box. Don't guess. If you don't know what the lawyer is saying, or if you don't understand the question, say, I don't understand your question. I did that multiple times in my 4-hour deposition on that Saturday back in 2002. Ask for clarification if you don't understand the question. You're an equal participant in the testimony. You're half of the equation. The lawyer's asking the question, you're providing the answers. That's 50% of the conversation. If you don't understand the question, you are a full participant. You're not the passive participant. The lawyer doesn't get to run all over you. Do be cooperative, but don't be forced into an inaccurate answer. Don't fight with the questioner or show anger or impatience. This was hard for me in mine. Being calm and not letting them see that you're irritated is challenging. When you feel that frustration working its way up from your gut and into your forehead, you have to push it down. It can be hard, but you have to do it. Because if you don't push it down, you're going to fight. You're going to say, stop. You're going to get irritated. But that doesn't help anybody. It's very important to be consistent, for your answers to be internally consistent. By internally, I mean internally, your story has to be consistent from beginning to end during your entire testimony, whether you're on the witness stand for 20 minutes or in a 4-hour deposition. The story you're telling from beginning to end has to be consistent. You can't say the woman drove up to the clubhouse and She drove up in a red Tesla and plugged it in, and then when she drove off, it was a white Tesla. You got to be consistent beginning to end. And stole the electricity. I'm going back to that story real quickly. All right, number 10, try to relax. I mean, it's hard because this is a challenging scenario. Bonus tip, don't be surprised when the judge asks his or her own questions. This surprises people every once in a while because you go in thinking, all right, I'm going to be asked questions by my own attorney. We call that direct examination. And I'm going to be asked questions by the other attorney called cross-examination. And then all of a sudden, before you're excused from the witness stand, the judge, all of a sudden, who's been taking notes on a yellow legal pad the entire time, the judge leans over to the witness box, witness stand. The judge is, next door. And the judge leans over and says, I have a few questions. And the lawyers sit down and the judge spends 15, 20 minutes asking his or her own questions. And because the judge has been listening to all of these questions for the last hour and a half, the judge's questions are more difficult than the attorney's questions. And now it's harder to be consistent because the judge was a lawyer in private practice for 30 years before taking the bench. So don't be surprised by that. And again, especially don't fight with this questioner. Be cooperative. Don't be forced into an inaccurate answer. Be consistent, still relaxed, and don't be surprised. Because I've seen this happen before where everything is going fine. We've prepared for the cross-examination. The direct examination was good. The cross-examination was tough, but fine. We got through it. And then the extremely skilled trial lawyer who decided to apply to be a judge gets his or her turn, and then the wheels fall off. We're no longer consistent. We're not relaxed. We're surprised. We didn't expect it. And oh no, we're in trouble. I've had a few situations in my career where I'm sitting at my table and I don't want to visibly do it because I don't want my witness, my client, my ride or die in this situation to see me do it. But internally, I'm doing this. Oh no, what have we done? But I would never do it visibly. We're in trouble. So a couple of additional thoughts where we get into trouble, and this is where proper preparation prevents poor performance. We call this the 5 Ps. Now, this is really lawyers talking to lawyers, the lawyer talking to myself. We have to prepare for trial. Trial is the lawyer's arena. We have to be great. And it's also a good opportunity for the witnesses to realize the lawyer has to prepare you as witness for what's happening. There's another issue that comes up every once in a while. I want to make you aware of it. Every once in a while, a homeowner's attorney will say to a professional community manager, how did you prepare for your testimony today? Did you meet with the association's attorney? And what did the attorney say? Because what the homeowner's attorney will say is that the association's attorney does not represent the management company. And there's no attorney-client privilege between Del Boca Vista's attorney and the management company, believing that the association's attorney has an attorney-client privilege with Del Boca Vista, but not with management company X that manages Del Boca Vista. The management company X may have its own corporate attorneys, but the attorney for Del Boca Vista doesn't necessarily have the attorney-client privilege with the management company. We're calling it management company X. So when the attorney for the HOA meets with the professional community manager who's employed by the management company, that the manager cannot claim that the conversation with the attorney for the association is privileged, and that the attorney for the homeowner is entitled to question the manager about the content of the conversation between the attorney for the association and the manager preparing for the testimony. So this comes up every once in a while where you get on the witness stand and the homeowner's attorney says on cross-examination, "One more question. How did you prepare for today?" Well, we already said, always tell the truth. That's number one. Well, the truthful answer is, I met with Scott Carpenter. Well, I've already said at the beginning of trial, I represent Del Boca Vista. And I did not say I represent Del Boca Vista's management company. Why would I say that? They're not a party to the trial. And so the attorney for the homeowner is going to say to the judge, "Your Honor, Scott Carpenter doesn't represent the manager. He doesn't represent the management company, the manager's employer, management company, whatever. There's no attorney-client privilege between the manager and Scott Carpenter. I'm entitled to ask her about the content of their conversation preparing for today's trial." And so every once in a while, this comes up. So the challenge here is the attorney well-versed and ready to argue that the attorney-client privilege extends to the manager to shield the manager from being forced to divulge these conversations? Now, as it turns out, these conversations may be non-problematic. I mean, what do? We talked about who, what, where, when. And we talked about the ledger. We talked about when you saw the purple gazebo. I mean, so what? I mean, so you testify about that. Maybe that's not all that harmful, but there are good legal arguments that the attorney-client privilege extends to the professional community manager to shield the manager from being forced to divulge those conversations. So we end up with the sixth P, pick the right lawyer. And so we've got the 5 Ps. We're going to call it the sixth P. Proper preparation prevents poor performance. Pick the right lawyer, because it's a bit of an uncomfortable situation. And I've seen managers sitting on the witness stand where the lawyer says, "Tell me about your preparation. Did you talk to Scott Carpenter before or fill in the blank lawyer, whoever, before you testified today?" And if it hasn't been discussed in advance, if there's no preparation for this topic, that everybody feels a little bit like a deer caught in headlights. And not every community association lawyer around is locked and loaded on this topic. And again, maybe these conversations are not overly problematic, but you got to be prepared. So that's an additional thought. All right. We do these webinar formats and we do Q&A. I have a couple of questions. Is refusing to answer a question equivalent to perjury? It's not exactly, but refusing to answer a question has to have a sound basis. One of the things that I meant to mention, but it slipped my mind, is uh, every once in a while we get confused, and in the old days, and I say old days, I don't mean that really, but we used to tell homeowners that their complaints would be kept confidential, and that was wrong. And the joke was homeowner complaint confidentiality. We talked a little bit about attorney client privilege just now, and there was never any homeowner professional community manager confidentiality where we could tell homeowners their complaints would be kept confidential. And that would be in the vein of this refusing to answer a question equivalent to perjury, like a manager might say, I'm not going to say who tattled. I'm just going to keep the homeowner tattler confidential. There is no confidentiality. But yes, refusing to answer a question is it could be a problem, but a judge would simply ultimately could hold you in contempt. It wouldn't be perjury, but it could be contempt for refusing to answer a question. Can you call for a short break during the deposition? I've seen that done, but it's really up to the lawyers and the court reporter. Um, there's this term that gets used every once in a while that kind of I don't like it. It's called a bio break. Go to the bathroom. That usually works pretty well if somebody needs to go to the bathroom. Um, that seems to be fine. Nobody seems to have a problem with that. But a short break because you want to confer with your lawyer, that's generally frowned upon. If you're just at a point where you don't know the answers, you want to get with your lawyer in the reception area or in the hallway, that usually won't work. It's really up to the lawyers, and um, that's usually not going to work. What do I see as management staff do the most that is wrong or embarrassing? In terms of testifying, I think it's that's wrong or most embarrassing. I think it's just being too concerned about it, quite frankly. Um, and I probably shouldn't say that, because we lawyers do this all the time, and we know that it's not that problematic and it shouldn't be something that we're too concerned about. Um, it's easier than you think. And when I've dealt with people who have testified, one of the most common reactions I get is, well, that wasn't so bad. It's a little easier than I thought. And so generally, um, I haven't seen anybody be embarrassed. I haven't seen anybody really do anything wrong. I think the key thing is to be confident in yourself, confident in the facts. One thing I would suggest, though, is definitely dress the part. Be ready for court. Guys, put on your suits if you have one. Dress up a little bit. Women, uh, dress up if you can. In my early on, I was talking to a lawyer when I was a very young lawyer, and the lawyer said, "Hey, in the summer it's so hot, you don't have to wear a suit and tie to court." And I thought, I think on my first trip to court, I'm going to wear a suit and tie anyway. And I went to court and I looked around, and every single person was in a full suit and tie, and I realized that this lawyer was completely messing with me. He was joking. He was just trying to see if I would, you know, make a fool out of myself. And I, of course, can't remember who it was, and forgot quite quickly who was messing with me. So I can't even get the lawyer back. Do you get paid to be a witness? When there's a subpoena and we're compelling someone, there's a very small fee that we have to send with it. I have to ask my paralegal how much it is, but it's a very small amount, like $12 or something like that, like $30. It's changed over the years. I can't remember exactly. But no, you don't get paid other than a very small amount, like supposedly for parking or something like that. But no, you don't get paid for a deposition either, because generally we do those in our conference room. So no, there's no nobody's making any money on this, unfortunately. So yeah, those are good questions. I think in general, um, if I were to leave you with anything, it's really the 11 things. And of course, we'll have the PDF here for anybody that wants it. We'll send it to you. I think this is really the heart and soul of it here. And if I were to really zero in on it, I think it's numbers 5, 6, 7, and 8. That's the heart of the top 11. And if I were to really say that's really the meat and potatoes of this whole thing is 5, 6, 7, and 8. Um, when you end up in this situation, that's where I would focus the most. Well, it's been a pleasure. Hopefully you enjoyed this and got something out of it. And as always, thanks for joining me on these monthly webinars. We'll do another one in November and then one in December. Thanks for joining me live. This will be on my website here at the Carpenter Law Firm within a couple of days. If anybody that you know missed it, you think it might be valuable, let them know. And as always, here at the Carpenter Law Firm, happy to help with any legal issues you might have here in Arizona for community associations. Thanks.